2023 prelims paper. English ಅಲ್ಲಿ ಹೇಳ್ಬೇಕಂದ್ರೆ it is called the mother of all papers. ಹಿಂದಿಲಿ ಹೇಳ್ಬೇಕಂದ್ರೆ it was the bap of all the papers. 2023 prelims paper was very difficult. So usually in polity, what is that we learned across the years from toppers? Polity na ಚೆನ್ನಾಗಿ ಓದ್ಕೊಳ್ಳಿ, polity ಮೇಲೆ ಕಂಟ್ರೋಲ್ ಇಟ್ಕೊಳ್ಳಿ, it will help you to clear prelims ಅಂತ ಹೇಳ್ತಾರೆ. 2020, 21, 22 this formula was applicable. But in the year 2023, even if you see the polity section, there are so many questions which are not possible to be done in the actual exam condition. So many new things were asked from polity. But there were certain easy questions from polity. Adanna now mistake ಮಾಡಬಾರ್ದಿತ್ತು. Difficult questions, yes. Every year certain section or certain part of the syllabus in the tough questions ಬಂದೇ ಬರುತ್ತೆ. 23 ಲಿ polity ಅಷ್ಟೇ ಅಲ್ಲ, ಬೇರೆ subjects ಅಲ್ಲಿ ಕೂಡ ಇತ್ತು. Whereas in 2024, again polity returned to the earlier stance. It became easy. 22 ಅಲ್ಲಿ easy to 21 ಅಲ್ಲಿ easy to 23 ಅಲ್ಲಿ slightly tough ಇದೆ. So this will happen. This is why UPSC is also termed as unpredictable public service commission. What the aspirants do not expect, what the aspirants do not think, that is what UPSC will do at once during few years. 23 ಅಲ್ಲಿ prelims ಅಲ್ಲಿ bouncer question ಇತ್ತು, 2024 ಅಲ್ಲಿ mains ಅಲ್ಲಿ questions ತುಂಬಾ bouncer ಆಗಿತ್ತು, and so on. This will keep on happening. So 2023 ಇನ್ನೊಂದು ಏನಂದ್ರೆ only one, only two, only three pattern ಅಂತ ಸ್ಟಾರ್ಟ್ ಆಗಿರೋದೇ 2023 ಅಲ್ಲಿ. 2022 ಅಲ್ಲಿ there were only around 5 to 6 questions which followed this pattern. And also 2023 ಅಲ್ಲಿ ಇನ್ನೊಂದು ಪ್ಯಾಟರ್ನ್ ರಿಪಿಟೇಷನ್ ಏನಂದ್ರೆ assertion and reasoning. Statement 1, statement 2 ಕೊಟ್ಟು statement 2 is the correct reason for statement 1 or it is the not the correct reason for statement 1. ಈ ತರ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ನ UPSC used to ask earlier 2000, 2002 ಈ ತರ ಟೈಮ್ ಲೈನ್ ಅಲ್ಲಿ UPSC used to ask those sort of questions. 21, 22, 2020 ಟೈಮ್ ಅಲ್ಲಿ ಈ ತರ ಕ್ವಶನ್ಸ್ ಇರ್ಲಿಲ್ಲ. So for someone who attempted 2023 actual UPSC paper, I did not talk about how difficult it was. But for someone who did not attempt, or for someone who is about to give 2026 as his first attempt, then this is a learning that you need to do. 2023 tough questions ittu, but the most important thing that the aspirant needs to keep in mind is easy questions na ಎಷ್ಟು ಕರೆಕ್ಟ್ ಆಗಿ ಆಗುತ್ತೆ ಅಷ್ಟು ಕರೆಕ್ಟ್ ಆಗಿ ಸಾಲ್ವ್ ಮಾಡಿ. ಟಫ್ ಕ್ವಶನ್ಸ್ ಇದ್ರೆ skip it for the second or third round. And even in the tough questions, see what are the subtle or small hints through which you can be able to answer it, whether it is correct or wrong. So 2023 paper na discuss ಮಾಡಬೇಕಾದ್ರೆ we'll come across all of this. So hello everyone, welcome to India4IAS. My name is Shreyas. So in this video we'll be discussing Polity 2023 PYQ questions. So we'll begin with the video. The essence, in essence, what does due process of law mean? Principle of natural justice, procedure established by law, fair application of law, equality before law. It is not about the procedure established by law. It is not equality before law. Aspirants in the actual exam got confused between these two, because I myself remember studying that due process of law means it has to follow the principles of natural justice and that the law that is being made has to be fair and reasonable. So natural justice ಬಗ್ಗೆನೂ ಓದಿದ್ದೆ, fair application of law ಬಗ್ಗೆ ಕೂಡ ಓದಿದೆ, but both the things have been asked in different options. So which one do I choose? In such cases we will have to choose the option which is more comprehensive. Principle of natural justice. Principle of natural justice ಅಲ್ಲಿ the law has to be not just fair, the law has to be just, fair and reasonable. ಈ ಮೂರು terms it fall under the principle of natural justice, and that is what is the due process of law. Whereas in the third statement it only mentions about the fairness, it doesn't speak about the law being reasonable. So E reason in the answer is A and not C. So what is this due process of law? India dalli we followed procedure established by law until the Maneka Gandhi case. It was in the Maneka Gandhi case that Supreme Court said that we need to adopt due process of law. Due process of law has been borrowed in India from the American Constitution. Due process of law has been borrowed from US. India dalli procedure established by law ittu. In the sense, a law could be made to deny a individual's personal liberty and right to life. Right to life and personal liberty for a given individual in India could have been denied through a law that was being made. This was before Maneka Gandhi case. Then Supreme Court said that if you want to deny a person of Article 21, which is right to life and personal liberty, then it can only happen if it follows due process of law. So any law that you make will not be valid. It will be only valid if it follows due process of law. which means that the law that has been made to deny Article 21, it has to be just, it has to be fair, and it has to be reasonable. It has to meet these three conditions. Even if we have to study more, see, a law being fair means equal opportunity should be given for the person to be heard, and there should be impartial tribunal that will be dealing with the case, and there should be orderly procedure, not any random set of things that will be dealt with, right? So this was due process of law which India adopted from Menaka Gandhi case 1978. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಪ್ರೊಸೀಜರ್ ಎಸ್ಟಾಬ್ಲಿಷ್ ಬೈ ಲಾ ಅಂತ ಇಂಡಿಯಾದಲ್ಲಿ ಇತ್ತು. ಆಫ್ಟರ್ ಮೇನಕಾ ಗಾಂಧಿ ಕೇಸ್ ವಿ ಗಾಟ್ ಡ್ಯೂ ಪ್ರೊಸೆಸ್ ಆಫ್ ಲಾ, and this due process of law, it is applicable in not only arbitrary executive action but also against arbitrary legislative action. So before this, arbitrary legislative action was not protected, but once we got the due process of law, we enhanced the power of the Supreme Court or the High Court to protect our individuals' right to life and personal liberty under Article 21. So this was an easy question, and this was the explanation which I wanted to speak about. We'll move ahead. In India, prisons are managed by state governments with their own rules and regulations for the day-to-day administration. See, PYQ repeat agide, I'll use a different thing. Prisons ಬಗ್ಗೆ banta. In last 2 year PYQs I was talking about prisons. Prison Act ಬಗ್ಗೆ ಮಾತಾಡ್ವಿ, state government power about prisons ಬಗ್ಗೆ ಮಾತಾಡ್ವಿ. Same subject has been picked. So 21-22 paper na ಚೆನ್ನಾಗಿ analyze ಮಾಡಿ ಈ ಟಾಪಿಕ್ಸ್ ಸ್ಟಾಟಿಕ್ ಪಾರ್ಟ್ ನ ಓದ್ಕೊಂಡಿದ್ರೆ ಈ ಕ್ವಶನ್ ಈಸಿಲಿ ಆನ್ಸರ್ ಮಾಡಬಹುದಿತ್ತು. See, prison and prison act ಬಗ್ಗೆ ಕೂಡ PYQ ಮಾತಾಡಿದ್ದಾರೆ, that too just 1 to 2 years back. So in India, prisons are managed by state governments with their own rules and regulations for day-to-day administration. I have already discussed this to be correct, that under the Prisons Act, state governments have the power to make rules and regulations. In India, prisons are governed by Prisons Act, which is correct, which expressly kept the subject of prisons in the control of the provincial governments. This is nothing but the state government. See, 1894 ಅಲ್ಲಿ they used to call it provincial government. Now ಈಗ state government ಅಂತ ಕರೀತಿದೀವಿ. So both statement 1 and statement 2 is correct, and statement 2 is the correct explanation for statement 1. This is the answer. So suppose now ಇದನ್ನ ಓದಿರ್ಲಿಲ್ಲ, suppose if we did not know this, how is that we could have answered? We'll see the other way. Statements ನೋಡಿ, prisons are managed by state government, okay, and state government has the power to make rules and regulations. When will a state government have the power to make rules and regulations? It will happen only if it is under its list. That means if the subject of prison is under the state list, only then can state government make law on the prison. Statement 2 is reinforcing statement 1. So statement 2 reinforcing statement 1 anta iddid case alli either statement 1 and statement 2 both are correct, or statement 1 and statement 2 both are wrong. Look at the options. Statement 1 and 2 both are wrong anna option illa. The only option that is available is statement 1 and 2 are correct, and statement 2 is reinforcing 1. So the answer becomes A. Even if you did not know anything, just by pure English basis, you could have deduced this. So this is where your aptitude and your smart thinking will come into play. Same thing, now static syllabus about the prisons. The prison state subject, it is under 7th schedule, list 2. So it will be dealt with Prisons Act. Now in the year 2023, we have Model Prisons Act. So Prisons Act 1894 had become old, it had become defunct. There was several provisions which were not in sync with the present timeline. So Model Prison Act madidare. I just listed a few of this. You please have a look at these provisions. See, parole for law will be promoted to the prisoners to encourage good behavior. We have already discussed in previous videos what parole is and what furlough is and what are the difference. Parole mel question bandide, furlough mel innu bandilla. So that is one important topic which we need to know. Special provisions for women and transgenders, this is also another thing. Now one thing which I want you to know is the Model Prison Act 2023 binding on the states? Like we spoke, prison comes under the state subjects. So Model Prison Act has been formulated by the central government. So the states have the right to adopt it or not adopt it. That is left to the states. But if the states adopt it, there will be uniformity. So states may or may not adopt it, and it is not binding on the states to adopt it. Idu namage gottirbeku, because this itself could become a statement in the subsequent years when a question will arise on prison. We'll move to the next question. Which one of the following statement best reflects chief purpose of the Constitution of India? I have said earlier also, limited power of the government is limited, constitutional supremacy. Idinne ಬೇರೆ ಬೇರೆ ರೀತಿಯಲ್ಲಿ they will try to formulate. chief purpose of Constitution of India. It determines the objective for making of necessary laws. Okay, it enables the creation of political offices and government. Okay, it defines and limits the power of the government. It secures social justice, social equality and social security. See, constitutionally all these provisions are there, but constitution of a country, it tries to limit the power of the government to prevent despotism or absolute power that has been possessed. So the constitution, wherever it is there, it will limit the power and it will ensure that it is supreme, so that there is no despotic rule in the country. So this is the most appropriate answer. So idinne next year matte bere riti ketare and it will continue so on. Another interesting question: in India, which one of the following constitutional amendments was widely believed to be enacted to overcome the judicial interpretation of fundamental rights? ಇಲ್ಲಿ confuse abadi last word na pick ಮಾಡಿ. So judiciary gave so many interpretation of fundamental rights. So which was that amendment which was enacted to overcome this judicial interpretation? 86th amendment ಬಗ್ಗೆ ಏನು ಗೊತ್ತು? Education was added as fundamental right. ಇದರಲ್ಲಿ ಒಂದೇ ಒಂದಿದೆ, ಮತ್ತೆ education as a fundamental right, ಇದ್ರ ಮೇಲೆ judiciary ಏನು ಆಪೋಸ್ ಅಥವಾ ತುಂಬಾ ಜಾಸ್ತಿ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಕೊಡಕ್ ಹೋಗಿಲ್ಲ. 44th also, all we know is right to property ಬಗ್ಗೆ it spoke about. This is also only just one thing. 42nd we know it is a mini constitution because so many changes happened. But we are talking purely about the fundamental rights, that judiciary gave interpretation of fundamental rights, and to overcome it parliament came with which of the following amendments? First constitutional amendment alli parliament made changes with article 15, it made changes with article 19, it inserted two other articles like article 31A, article 31B, and all this had been done to overcome the judicial interpretation of fundamental rights. So this is first constitutional amendment is the correct answer to this question. UPSC li ee question X anta tagondru, I don't know why, maybe there was a mistake in the Hindi paper with respect to printing, so that is why maybe they took it as wrong, but the answer to this is 1. So 15th alli social and economically backward section ge there will be provisions which will favorable them, ಆ amendment na add ಮಾಡಿದ್ರು. Article 19 alli there is freedom of speech and expression. Now the restriction on freedom of speech and expression that had been widely that got widened by adding other provisions like friendly relation with foreign states or incitement to offense. E provision or e grounds na to restrict article 19 na kuda add ಮಾಡಿದ್ರು through first constitutional amendment. First constitutional amendment alli article 31A, saving of laws when it came to acquisition of estates. So there were certain laws which provided for acquisition of estates, and to protect the judiciary from reviewing that, it was been added under 31A. And 31B, which is very very famous, 31B, the articles under 9th schedule. So if the parliament wants a certain law not to be reviewed by the judiciary, then it will keep it under 31B. So this is one of the provisions that have been added, and this is very famous. Nowadays there are controversies going around with reservation. For example, now Karnataka has 56% reservation, which is under very much of contradiction. So what Indira Sawhney case said, it spoke of only 50%, but here there is 56%. So how can this be protected? If the parliament agrees to keep this law under article 31B, then only in that case can it be protected, right? Current affairs joteno connect madaitu. We'll move ahead to the next question. First Amendment Act, same thing which I spoke of, it added more grounds such as freedom of speech and expression on the restriction of public order, friendly relation, foreign estates, incitement of offense, and so on. Same thing which I discussed. Another simple question: which of the following bodies are constitutional bodies? See, basic thing, constitutional bodies ಅನ್ನೋದು ಎಷ್ಟಿದೆ ನಮಗೆ ಗೊತ್ತಿದೆ. Which are the constitutional bodies that we have? NC, SC, NC, ST, NC, BC. Then rest of the bodies we know: Election Commission, CAG, these officers, UPSC, SPSC, and so on. Linguistic minorities kuda constitutional official baratte. NHRC is a statutory body that is been established under Protection of Human Rights Act 1993. NCBC became a constitutional body through 102nd amendment. National Law Commission is neither a statutory body nor a constitutional body. How many law commissions have been established? 1 plus 21. ಈ 1 ಅನ್ನೋದು ಲಾರ್ಡ್ ಮೆಕಲೆಂಡರ್ ಎಸ್ಟಾಬ್ಲಿಷ್ ಆಗಿತ್ತು. ರಿಮೈನಿಂಗ್ 21 law commissions have been established till now. What does law commission do? Law commission will review the existing laws or it will make recommendations to the government to make certain laws. UPSC mains al pade pade we keep on writing law commission recommendation, law commission. This is that thing, but it is not a constitutional body. National Consumer Disputes Redressal Commission, it is also statutory body established under Consumer Protection Act, and this body idr mele nodi question bandilla, there is good chance. National Consumer Disputes Redressal Commission, it is been headed by the Prime Minister. We'll move ahead. If the election of the President of India is declared void by the Supreme Court of India, all the acts done by him or her in the performance of duties of his or her office of President before the date of decision becomes invalid. See, unwanted statements they frame just to make it wrong. It is a wrong statement. Whatever has been done by the President, it will still remain even if his office, even if he is taken out from his office. All the decisions made will still be valid. So second statement, election for the post of President can be postponed on the ground that some legislative assemblies have been dissolved and elections are yet to take place. This is also wrong. See, President election alli who are the members who participate, we need to know. Elected members from the parliament, elected members from the state legislative assembly. So idu namige gottirbeku, nominated members are not involved, and also elected members of the assembly of Delhi. So Delhi and Jammu Kashmir. So this is also another thing which we need to know. These are the members who participate in the presidential election. And see, state government or state assemblies dissolve agide just because 1 or 2 state assemblies got dissolved. Other reason in the president election na we cannot postpone. President office is very much needed because assent to bills made by the parliament kodbekate. So there are so many states. So 1 or 2 state assembly dissolve aitanta, we cannot make the president election to be waiting. So this is a wrong thing. When a bill is presented to the President of India, the constitution prescribes time limit. See, idu nodi one trap tara. Unwantedly, when a bill is presented to the President, the constitution prescribes time limit within which he or she is to declare or provide their assent. This is also another wrong statement. There is no time frame. So answer becomes only 1. See, when a bill is been sent to the President, there is no time frame for the President to take this. Now this thing is called pocket veto. Same thing the governor had, but Supreme Court in recent judgments has restricted this. So the governor does not enjoy absolute pocket veto. Now, whenever the state legislature will forward the bill to the governor, he cannot enjoy absolute pocket veto as the President does now. Adanne Supreme Court reasonable time frame ant helidare. It is around 3 months as of now. Same thing which I spoke of. With reference to finance bill and money bill in the Indian Parliament, consider the following statements. When the Lok Sabha transmits finance bill, Rajya Sabha can amend and reject the bill. Okay. When the Lok Sabha transmits money bill to Rajya Sabha, it cannot amend or reject the bill because it can only make recommendations. See, money bill basic thing, money bill will be dealt with Article 110. So money bill Lok Sabha matra introduce ಮಾಡ್ತಾರೆ. Rajya Sabha can only make recommendations. Neither can it make amendment nor can it reject the bill. Idu namige ಗೊತ್ತಿರಬೇಕು. In the case of disagreement between Lok Sabha and Rajya Sabha, there is no provision for joint sitting for money bill, but a joint sitting becomes necessary for finance bill. There is no joint sitting for money bill is correct, but a joint sitting becomes necessary for finance bill. Now we need to differentiate what this finance bill is and what this money bill is. See, finance bill is a broad category. So finance bill ee tara idre, money bill is a small part of the finance bill. So whatever matters are dealt under Article 110, they fall under money bill. If the government wants to impose remission of any taxes, then that is dealt with Article 110. If the government wants to deal with a receipt or with the expenditure from Consolidated Fund of India, then also those matters will be dealt under Article 110. Finance bill anta maatadadaga there is 2 other subcategories, finance bill 1 and finance bill 2. ಸಿ ಇದ್ರ ಬಗ್ಗೆ ಗೊತ್ತಿರಬೇಕು. Finance Bill 1. These are the bills which deal with Article 110 and other matters of general legislation. Other matters of general legislation. Finance Bill 1 can only be introduced by Lok Sabha, that too with the previous consent of the President, but it can be amended by Rajya Sabha. And if the Rajya Sabha does not agree, there is a provision for joint sitting also. Whereas Finance Bill 2, all those matters which involve making expenditure from Consolidated Fund of India, but those matters which do not fall under Article 110. So Article 110 ಅಲ್ಲಿ ಬರೋ ಮ್ಯಾಟರ್ಸ್ ಆಗಿದ್ರೆ ಮನಿ ಬಿಲ್. ಔಟ್ಸೈಡ್ Article 110 ಅಲ್ಲಿ ಬರೋ ಆರ್ಟಿಕಲ್ಸ್ which involves expenditure from Consolidated Fund of India, then it is under this article. And this article or this Finance Bill 2 normal legislation ಹೆಂಗೆ ಪಾಸ್ ಆಗುತ್ತೆ, ಸೇಮ್ ಬಿಲ್ ಪ್ರಾವಿಷನ್ಸ್ ಅಪ್ಲಿಕೇಬಲ್ ಆಗುತ್ತೆ. It can be introduced in Lok Sabha or Rajya Sabha. It does not need the prior consent of the President to be introduced. Rajya Sabha can amend, and there is provision of joint sitting also. So this is what Finance Bill 1 and 2 is. So general Finance Bill ಹೇಳಿದ್ದಾರೆ. When the Lok Sabha transmits Finance Bill to the Rajya Sabha, it is talking about Finance Bill in general. So Rajya Sabha will have the power to amend or reject the bill. This is a correct statement. When the Lok Sabha transmits money bill to Rajya Sabha, it cannot amend or reject, it can only make recommendations. This is also correct. In case of disagreement between Lok Sabha and the Rajya Sabha, there is no joint sitting, but a joint sitting becomes necessary for Finance Bill. This was one of the controversial things asked by UPSC actually, because in this case, see, joint sitting becomes necessary. Now this necessary is a very big word. It is not necessary. Answer to this question is B. But ಈ ತರ ಪ್ಯಾಟರ್ನ್ ಬಂದಾಗ UPSC ಏನಾಗಿದೆ, ಮುಂಚೆ ಹೆಂಗಿತ್ತು 1 2 3 ಅಂತ ಇತ್ತು, we know which is the exact answer. ಈಗಿನ ಟೈಮಲ್ಲಿ ಏನಾಗಿದೆ, UPSC will tell B is the answer, but which of these two is correct ಅನ್ನೋದು ಇಶ್ಯೂ ಆಗಿರುತ್ತೆ. ಸೊ ಇಲ್ಲಿ in case of disagreement between Lok Sabha and Rajya Sabha, joint sitting becomes necessary for Finance Bill. It is not actually necessary. So this is a wrong statement. So answer to this question is B. See, money bill, all money bills are financial bills, but all financial bills are not money bills. Bill that includes revenue or expenditure that needs to be done, these are finance bills. Okay, we'll move ahead. Now, with reference to scheduled areas in India, consider the following statement. Scheduled area, previous question already matadvi. We also studied the static syllabus associated with it. So we should be able to answer this question. Within a state, the notification of a scheduled area, it happens on the order of President and not Governor. Be careful, President Jagdal, Governor koda chances irutte. The largest administrative unit for scheduled area is district and lowest is cluster of villages, which is nothing but taluk level. Makes sense. Yeno tumba unique, tumba contradictory anta illa. It's correct. Chief Minister of the states are required to submit annual reports to Union Home Ministry. See, annual reports alla kododu yaru? It is the Governor and not the Chief Minister. It is the Governor who is required to make annual reports to the Union Home Ministry on the administration of scheduled areas. So this is wrong and this becomes correct. It was an easy question. Same thing like I spoke of, see 10 states which fall under the 5th schedule. Gottirbeku, ella pakpakane ide, Andhra, Chhattisgarh, Gujarat, Jharkhand, Himachal. Himachal is the only one out of the picture. Madhya Pradesh, Maharashtra, Odisha, Rajasthan, Telangana. I spoke of this in previous video also. And the executive power of the union shall extend to giving directions to the state when it comes to administration of scheduled areas. Said areas antagide, this is scheduled areas. So if it is scheduled areas, the center can direct the state executive action. Center has that power. But a scheduled area, which are the areas which fall under this? One, it should have substantial amount of tribal population. It should be of reasonable size. It should have units such as district, block or taluk. And it should be economically backward. So, E provisions idre, it will fall under the 5th schedule. And who declares 5th schedule? President. Moving ahead. Next question. The Supreme Court of India has held in some judgments that the reservation policies made under Article 16 subclause 4 of the Constitution of India would be limited to Article 335 for maintenance. Would be limited by Article 335 for maintenance of efficiency of administration. This is a statement, okay. Article 335 of the Constitution of India defines the term efficiency. We have already spoken, defines, classifies. these things tend to be wrong. Article 335 could have made a mention of the term efficiency of administration. Idu nam mind ge barbeku, not defined. So 2 wrong adre, see ee tara statement 1 statement 2 biggest advantage ಏನಂದ್ರೆ statement 2 wrong ಅಂತ ಗೊತ್ತಾಯ್ತಾ, statement 1 wrong ಅಂತ ಗೊತ್ತಾಯ್ತಾ, direct answer ಬಂದ್ಬಿಡುತ್ತೆ. So statement 2 is wrong, statement 2 is incorrect, so statement 1 becomes correct. This is the only option that will fit into the picture, right? It was a very easy question which we could have deduced even without any knowledge. So idra baggene ಸ್ವಲ್ಪ static part ನೋಡೋ ಹಾಗೆ ಇದ್ರೆ, what is that we can see? Article 335 of the Constitution, it tells that the claim of the member of SC and ST are to be taken into consideration with the maintenance of administration of efficiency. So Article 335 ಏನು ಹೇಳ್ತಿದೆ, SC ST ಗೆ ರಿಸರ್ವೇಷನ್ ಕೊಡ್ತೀರಾ, it's fine, SC ST ಗೆ ಪ್ರಮೋಷನ್ ಕೊಡ್ತೀರಾ, okay, but try to balance that with the efficiency in the administration. So it was in M. Nagaraj case, Supreme Court said 3 things needs to be maintained. SC ST ಗೆ if you are providing promotion in public employment, then one condition is that they should be socially and economically backward. Second condition is that they are not adequately represented. And third condition that they shall not affect the efficiency. Ella reservation basis ಮೇಲೆ ಕೊಟ್ಟರೆ efficiency effect ಆಗೋ chances ಇರುತ್ತೆ, but efficiency should not be compromised. Compromise ಮಾಡದೆ ನೀವು reservation provide ಮಾಡಬೇಕು ಅನ್ನೋ condition. Similar thing was been said in Jarnail Singh case also, that it actually relaxed the thing that state need not produce quantifiable data to prove the backwardness. So ಇಲ್ಲಿ 3 ಕಂಡೀಷನ್ ಇತ್ತು ಬ್ಯಾಕ್ವರ್ಡ್ನೆಸ್ ನ ಪ್ರೂವ್ ಮಾಡಬೇಕಂತ. ಜರ್ನಲ್ ಸಿಂಗ್ ಕೇಸ್ ಅಲ್ಲಿ ವಿದೌಟ್ ಡೇಟಾ ಆಲ್ಸೋ ಯು ಕ್ಯಾನ್ ಟೆಲ್ ದಟ್ ಇಟ್ ಇಸ್ ಬ್ಯಾಕ್ವರ್ಡ್ ಅನ್ನೋದನ್ನ ಹೇಳಿದೆ ಅಷ್ಟೇ. We'll move ahead. These 2 cases are important even for mains when it comes to efficiency administration or dealing with SC ST in public employment. Next question. According to the Constitution of India, central government has a duty to protect states from internal disturbance. Now idರಲ್ಲಿ ಏನು ಡೌಟ್ ಇರಬಾರ್ದು, this is according to Constitution of India also, India only, and it falls under Article 355. Emergency chapter ಓದ್ತೀವಿ ಅಲ್ವಾ, so Article 352 in the Article 360 ಯಾವ articles ಬರುತ್ತೆ along with Article 365, this much we should know. So this is nothing but Article 355. Second statement, Constitution of India exempts the state from providing legal counsel to a person being held for preventive detention. This is also important provision that we need to know. See, Article 22, protection against arrest and detention, is what Article 22 acts as the fundamental right. So Article 22 only there is protection against arrest and detention, but there are 2 grounds where this protection shall not be extended. One is that that person is an enemy alien. Enemy alien andre he is from a foreign country and we do not have a good relation with that country. It is a enemy country and he is a foreigner from that country. Adu ಒಂದು. ಮತ್ತು ಇನ್ನೊಂದು, if the person is under preventive detention, then this protection which is available under Article 22 shall not be extended. Same thing na ಹೇಳಿದ್ದಾರೆ, so this becomes correct. According to Prevention of Terrorism Act 2002, confession of the accused before the police cannot be, ಮತ್ತೆ ಟ್ರ್ಯಾಪ್ cannot be used as evidence, it can be used as evidence. ಸ್ಟೇಟ್ಮೆಂಟ್ ನ ಕರೆಕ್ಟ್ ಆಗಿತ್ತು, ಸುಮ್ಮನೆ cannot ಅನ್ನೋ ವರ್ಡ್ ನ ಎಕ್ಸ್ಟ್ರಾ ಆಡ್ ಮಾಡಿದ್ದಾರೆ ಜಸ್ಟ್ ಟು ಮೇಕ್ ದ ಸೆಂಟೆನ್ಸ್ ರಾಂಗ್. ಸೊ ಎಲ್ಲಿ ಸೆಂಟೆನ್ಸ್ ರಾಂಗ್ ಅಂತ ತಗೊಳ್ಳೋದು, ಎಲ್ಲಿ ಸೆಂಟೆನ್ಸ್ ರೈಟ್ ಅಂತ ತಗೊಳ್ಳೋದು, ದಿಸ್ ಮೈಟ್ ಬಿ ಅನದರ್ ಥಿಂಗ್ ವಿಚ್ ಮೈಟ್ ಕಮ್ ಟು ಯುವರ್ ಮೈಂಡ್ ನೌ. ಸಿ, ಎಲ್ಲೆಲ್ಲಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ನೆಗೆಟಿವ್ ಇರುತ್ತೆ ಕಾಮನ್ಲಿ ವಿ ಟೇಕ್ ಇಟ್ ಎಸ್ ರಾಂಗ್, ಬಟ್ ಬ್ಲೈಂಡ್ಲಿ ಅದನ್ನು ಫಾಲೋ ಮಾಡಬೇಡಿ. ಫಸ್ಟ್ ಸಿ ಇಫ್ ದ ಸ್ಟೇಟ್ಮೆಂಟ್ ಈಸ್ ವಿದಿನ್ ಯುವರ್ ನಾಲೆಜ್ ಬೇಸ್. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, Constitution of India exempts, ಈಗ ನೀವು ಎಕ್ಸಾಮ್ಸ್ ನ ರಾಂಗ್ ಒನ್ ಅಂತ ತಗೊಳಕಾಲ, ಬಿಕಾಸ್ ದಿಸ್ ಇಸ್ ಅ ಬೇಸಿಕ್. Article 22 ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್, ಪ್ರಿವೆಂಟಿವ್ ಡಿಟೆನ್ಷನ್ ಇಸ್ ನಾಟ್ ಅಪ್ಲಿಕೇಬಲ್ ಅಂಡರ್ ದಿಸ್ 2 ಕಂಡೀಷನ್ಸ್, ಇದು ಗೊತ್ತಿರಬೇಕು. ಸೊ ಬ್ಲೈಂಡ್ಲಿ ಎಕ್ಸಾಮ್ ಅಂದ್ಬಿಟ್ಟು ರಾಂಗ್ ತಗೊಳ್ಳೋದಲ್ಲ, ಸೊ ಇದು ಗೊತ್ತಿರಬೇಕು. ಬಟ್ ಅಬೌಟ್ ದಿಸ್ ವಿ ಹ್ಯಾವ್ ನಾಟ್ ಸ್ಟಡಿಡ್. ಓನ್ಲಿ ಇಫ್ ಯು ಆರ್ ನಾಟ್ ಸ್ಟಡಿಡ್ ಸಮಥಿಂಗ್ and there is negative thing, only then you take it as wrong. But if it is something which you have studied, then you should be able to answer it. Exam kodli kodegirli, negative irli ildegirli, you should know about it. Even this thing is Article 355, you should be knowing about it. So the answer to this question is B. We'll move to next question. Same thing which Article 355 which I spoke of, and Article 22 does not protect enemy alien and a person who is being kept under preventive detention. POTA, quota has been taken out now. I don't know why they asked a question on this. So a confession, if it is been made for not lower than the rank of SP, then it shall be admissible. Quotadal admissible ittu, but then we got to know that it could be misused by someone in power like a SP. So UAPA Act, which replaced quota, now it does not accept these confessions. ಮುಂಚೆ ಈ ತರ ಕನ್ಫೆಷನ್ ಮಾಡ್ರೆ ವ್ಯಾಲಿಡ್ ಇತ್ತು, ಈಗ UAPA ಅಂಡರ್ ವ್ಯಾಲಿಡ್ ಇಲ್ಲ. We'll move to next question. Which of the following statements in respect of election of President of India? So consider the following statements in respect of election to the President of India. This is another bouncer. Statements na nodi worry agbedi. We'll look at it one by one. The members nominated to either houses of the parliament or legislative assemblies of the state are also eligible to be included. See, nominated members are not eligible. Basic thing is naಮಗೆ ಗೊತ್ತಿರಬೇಕು that this is wrong. Adre 1, 2, 3, 4 illa. So we'll have to judge each of these statements one by one. Higher the number of elective assembly seats, higher is the value of vote of each MLA. See, president chapter ಓದಿದಾಗ ನಮಗೆ ಬೇಸಿಕ್ಸ್ ಗೊತ್ತಿರಬೇಕು. How is the value of vote? The value of vote of a MLA, how is it been calculated? The value of vote of MLA of each state varies, but the value of vote of MLA within the state ಯಾವ MLA ಇದಾರೆ ಅವ್ರ ವ್ಯಾಲ್ಯೂ ಸೇಮ್ ಇರುತ್ತೆ ಪ್ರೆಸಿಡೆಂಟ್ ಎಲೆಕ್ಷನ್ ವೋಟಿಂಗ್ ಅಲ್ಲಿ. ಆದರೆ ಬಿಟ್ವೀನ್ ದ ಸ್ಟೇಟ್ಸ್ ಇಟ್ ವಿಲ್ ವೇರಿ. Value of vote of a MLA will be dependent upon the population of the state divided by the number of elected MLA seats. So ಈ ಫಾರ್ಮುಲಾ ಇಂದ ನಮಗೆ ಏನು ಗೊತ್ತಾಗುತ್ತೆ? Higher the number of elective seats is in the denominator. Higher, if this is higher, that means this will be lower. So idu kuda wrong. Ee vedo basic things, whereas 3 and 4 all we could do is take a good guess or just leave it. So nodi idan deduce madak agalla. 3 ಮತ್ತೆ 4 they are very difficult. Why? The value of vote of each MLA of MP is greater than that of Kerala. Iga MP dal what is the population and what is the number of elected seats? Illi issue ಏನಂದ್ರೆ both these are directly related. For instance, Madhya Pradesh has more population than Kerala, correct? What about the elected number of seats? When population is the most important basis for allotment of seats, then more the population, more will be the elected number of seats. So directly proportional agate both the factors. So it becomes very difficult to compare Madhya Pradesh and Kerala. Similarly, the value of vote of each MLA of Pondicherry is higher than that of Arunachal Pradesh, and same thing. Here also it becomes very difficult. So guesswork athwa ee question item madbekandre what is that we could have done? We know that 1 is wrong, knowledge basis mele. 2 is wrong, knowledge basis mele. 3 ಮತ್ತೆ 4 madhya we do not know, and both of them we'll have to take a guess. So like I said, always take the madhya marg of Buddhism. Madhya marg of Buddhism or golden mean of Aristotle ಏನು ಮಾಡ್ತೀವಿ? ಎರಡು ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ, there is good chance that one will be correct and one will be wrong. ಯಾವ್ದು ಕರೆಕ್ಟ್ ಗೊತ್ತಿಲ್ಲ, ಯಾವ್ದು ರಾಂಗ್ ಗೊತ್ತಿಲ್ಲ. So only 2, 1 correct, okay, only 1, sorry, only 1, because this is wrong. So in these two statements we can take 1 to be wrong and 1 to be correct. So answer would have been only 1, and the answer actually tended to be only 1. ಇದು ಹೇಗೆ ಗೊತ್ತಾಯಿತು? Presidential election, the vote value of each MLA of Pondicherry was more and Arunachal Pradesh was less. It is very difficult to tell this. Also, the value of vote of each MLA of Madhya Pradesh is less than that of Kerala. Idu kuda we couldn't have estimated or even guessed for that reason. So that question was better meant to be left, or if you have to take a guess, you have to do 50-50. Next question. With reference to home guards, ಈ home guards ಬಗ್ಗೆ ನಾವು ತುಂಬಾ ಏನು ಓದಿರಲ್ಲ, but we might have heard it somewhere when we were studying current affairs. Home guards are raised under Home Guards Act, seems proper. And rules of central government. See, central government, state government replace ಮಾಡೋ chances ಇರುತ್ತೆ. Let this be in mind. We look at the other options. The role of home guards is to serve as an auxiliary force to the police in maintenance of internal security. Generic agide. To prevent infiltration of international border coastal areas, border wing home guards battalions have been raised. Idu kuda generic agide. And statement 2 and statement 3 are going hand in hand. ಅಂದ್ರೆ ಸ್ಟೇಟ್ಮೆಂಟ್ 2 ಇದ್ರೆ ಸ್ಟೇಟ್ಮೆಂಟ್ 3 ಪಾಸಿಬಲ್ ಇಲ್ಲ, ಆ ತರ ಇಲ್ಲ. ಸ್ಟೇಟ್ಮೆಂಟ್ 3 ಅಂಡ್ ಸ್ಟೇಟ್ಮೆಂಟ್ 2 ದೇ ಆರ್ ಗೋಯಿಂಗ್ ಹ್ಯಾಂಡ್ ಇನ್ ಹ್ಯಾಂಡ್, ದೇ ಆರ್ ಸಪೋರ್ಟಿಂಗ್ ಈಚ್ ಅದರ್. ಸೊ 2 ನ ಕರೆಕ್ಟ್ ತಗೊಂಡ್ರೆ 3 ನು ಕರೆಕ್ಟ್ ತಗೊಬೇಕು, ಅಥವಾ ಎರಡನ್ನೂ ರಾಂಗ್ ತಗೊಬೇಕು. ಸೊ 2 ಮತ್ತೆ 3 ಕರೆಕ್ಟ್ ಆಗಿ ತಗೊಂಡ್ರೆ ವಾಟ್ ಅಬೌಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ 1? ಹೋಮ್ ಗಾರ್ಡ್ಸ್ ಆರ್ ರೇಸ್ಡ್ ಅಂಡರ್ ಹೋಮ್ ಗಾರ್ಡ್ಸ್ ಆಕ್ಟ್, ಓಕೆ, ಬಟ್ ದೇ ಫಾಲ್ ಅಂಡರ್ ರೂಲ್ಸ್ ಆಫ್ ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಅಂಡ್ ನಾಟ್ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್. ಸೊ ಗೆಸ್ ವರ್ಕ್ ತಗೊಳ್ಳೋ ಹಾಗೆ ಇದ್ರೆ it is not only one, it is not none. Either we have to take B or C, but if you are aware about the traps of UPSC, that central government ಜಾಗದಲ್ಲಿ ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಕೊಟ್ಟಿರಬಹುದು, ಅಥವಾ ಹೇಗೆ ಮಿನಿಸ್ಟ್ರೀಸ್ ಚೇಂಜ್ ಮಾಡ್ತಾರೆ ಒಂದರಿಂದ ಇನ್ನೊಂದು, ಈ ತರ ಟ್ರಾಪ್ಸ್ ಕೊಡುತ್ತೆ ಅಂತ ಗೊತ್ತಿದ್ರೆ then we could have gone for only 2, right? So same thing which I said, home guards, it is a state subject dealt with Home Guards Act. They are recruited from all classes, especially those who are voluntarily agreeing. So 10th pass basis ಮೇಲೆ ಹೋಮ್ ಗಾರ್ಡ್ಸ್ ನ ರಿಕ್ರೂಟ್ ಮಾಡ್ತಾರೆ. There are 15 border wing home guards battalions mainly across the border states, Tripura, Meghalaya, Punjab and so on, and they prevent the infiltration of international borders or the coastal areas. See, home guards ಮೇಲೆ ಮತ್ತೆ ಕ್ವೆಶ್ಚನ್ ಬರುತ್ತೆ, I don't expect that, but just a basic knowledge about it. With reference to India, consider the following pairs. ಇದು ಕೂಡ ಬೌನ್ಸರ್ ಸಾರ್ಟ್ ಆಫ್ ಕ್ವೆಶ್ಚನ್ because we do not come across this normally. Unauthorized wearing of police or military uniforms, Official Secrets Act. Knowingly misleading or otherwise interfering with a police officer when engaging in duties, Indian Evidence Act. Celebratory gunfire which can endanger personal safety to others, Fires Act. See, ಏನು ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ this question was better meant to be left. ಅಥವಾ ಗೆಸ್ ವರ್ಕ್ ತಗೊಳ್ಳೋ ನೆಸೆಸಿಟಿ ಇಲ್ಲ, ಯು ಆಲ್ರೆಡಿ ಅಟೆಂಪ್ಟೆಡ್ ಅರೌಂಡ್ 90+ questions or 90 questions, then this question was meant to be left. But if you still wanted to attempt because you attempt very less number of questions, then how is that we could have attempted? ಅದನ್ನ ನೋಡೋಣ. See, Arms Act, and it is talking about gunfire, so there is good chance that this could be correct. Misleading, knowingly misleading or otherwise interfering with a police officer. So if you are interfering with a police officer, Indian Evidence Act under Y. Indian Evidence Act, what does it involve? It will involve those provisions which deals with the material that is permissible to be accepted in court or to accept a certain crime. So it is dealing with the evidence, not with interfering with police. So ಇದನ್ನ wrong ಅಂತ ತಗೊಬೋದಿತ್ತು. So one wrong, one correct ಆದ್ರೆ the answer should have been only A or only B. Unauthorized wearing of police uniforms, Official Secrets Act. If you do not know anything, we could have taken it to be wrong or right and do 50-50. So ಇದನ್ನ attempt ಮಾಡಬೇಕಂದ್ರೆ we could have attempted it this way. The answer actually to this is correct. So the answer to this is B because statement 1 is correct. See, E acts will not study in detail also because there is very less chances that will be asked again. This is another bouncer. The end of this paper is dealing with a lot of bouncers. With respect to the national flag of India, according to the flag code of India, flag code, national flag, idra ಬಗ್ಗೆ ನಾವು ಓದೇ ಇರಲ್ಲ, these are bouncers. One of the standard size of national flag is this much. 60 mm ಅಂದ್ರೆ ಎಷ್ಟು ಬರುತ್ತೆ? 60 cm ಬರುತ್ತೆ. 60 cm ಅಂದ್ರೆ ಇದು 10, 20, 30, 40, 50, 60. This would be the size that it is talking about. 10, 20, 30, 40. So this is the standard size that is talking about, which is less, seems less. One of the standard size of national flag is this much. The ratio of length to height. The ratio of length to height. The ratio of length to height of the flag shall be 3:2. See, nodi, those who are good with aptitude or maths, they would have saw this relation 600 mm, 400 mm in the ratio 3:1. ಇದನ್ನ ಕೂಡ ಡಿವೈಡ್ ಮಾಡಿದ್ರೆ 3:2 ರೇಷಿಯೋ ಬರುತ್ತಾ? Sorry. So in that sense, many of us would have taken option A to be correct. Even I did the same thing. But statement 1 is wrong because these dimensions given are wrong. They are in the ratio 3:2 but not these dimensions. That is why answer to this question is D. So this was a bouncer. So aptitude ಚೆನ್ನಾಗಿದ್ರು ಕೂಡ, ಮೈಂಡ್ ಆಕ್ಟಿವ್ ಇದ್ರು ಕೂಡ ನಾವು ಆನ್ಸರ್ ನ A ಚೂಸ್ ಮಾಡ್ತಿದ್ವಿ. ಬಟ್ UPSC ಗೊತ್ತಾಯ್ತು ಇವ್ರು ಥಿಂಕ್ ಮಾಡ್ತಾರಂತ. ಸೊ ಥಿಂಕ್ ಮಾಡಿದ್ರು ಕೂಡ ಕ್ವಶನ್ಸ್ ನ ರಾಂಗ್ ಮಾಡ್ಸುತ್ತೆ. ಸೊ ದೀಸ್ ಆರ್ ದೋಸ್ ರಿಸ್ಕಿ ಕ್ವಶನ್ಸ್. ಸೊ ದಟ್ಸ್ ವೈ ಐ ಸೆಡ್ polity paper was at a slightly difficult note in 2023. Look at the last question. With respect to the Constitution Day is celebrated on 26th November. Correct, because 26th January we are celebrating Republic Day. So the Constitution Day or the National Law Day is been celebrated on 26th November every year to promote constitutional values among citizens. This is correct. So adike reason 26th November 1949 Constituent Assembly of India set up drafting committee under the chairmanship of Ambedkar to prepare a draft constitution. ಸುಮ್ಮನೆ ಫ್ಲೋ ಅಲ್ಲಿ ಓದ್ಬಿಟ್ಟು ಫ್ಯಾಕ್ಟ್ಸ್ ಕರೆಕ್ಟ್ ಇದೆ ಅಂತ ಮಿಸ್ಟೇಕ್ ಮಾಡೋದು ಹೋಗಬೇಡಿ. ವೈ ಡು ವಿ ಸೆಲೆಬ್ರೇಟ್ Constitution Day on 26th November? Because on 26th November 1949 we adopted the constitution, and the constitution that we adopted was enforced from 26th Jan 1950. It is not because Ambedkar was appointed as the chairman of drafting committee. The only person who was appointed as the chairman of drafting committee was Ambedkar, and it was not in 1949. Just think, independence sikkirodu 1947. Independence sikkiದ ತಕ್ಷಣ 1947 ಗೆನೆ the drafting started. The drafting started in 1947, and almost after more than 2 years, 1949 end hatra the drafting of constitution got completed. November 1949 ಗೆ drafting committee na appoint ಮಾಡಿದ್ರೆ ಅಂಬೇಡ್ಕರ್ ಜೊತೆ 1952 ಅಥವಾ 1953 ಟೈಮಲ್ಲಿ constitution would have been enforced, because we needed more than 2 years to formulate our constitution. So this is also a simple question. 1 is correct, whereas 2 is wrong. So the answer is C. See, this itself could be asked as a indirectly, it could be asked as a direct question. The drafting committee was set up in the, they could even ask date. UPSC li date ಕೊಟ್ಬಿಟ್ಟು ಆ ಡೇಟ್ ಅಲ್ಲಿ ಪರ್ಟಿಕ್ಯುಲರ್ ಡೇಟ್ ಅಲ್ಲಿ ವಾಟ್ ಹ್ಯಾಡ್ ಹ್ಯಾಪನ್ ಅಂದ್ಬಿಟ್ಟು ಆಪ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ರು. ಆಪ್ಷನ್ ಎ ನಾನ್ ಕೋಪರೇಷನ್ ಮೂವ್ಮೆಂಟ್, ಆಪ್ಷನ್ ಬಿ ಕ್ವಿಟ್ ಇಂಡಿಯಾ ಮೂವ್ಮೆಂಟ್ ಅಂತ ಕೇಳಿದ್ರು. ಸೊ ಡ್ರಾಫ್ಟಿಂಗ್ ಆಫ್ ಅವರ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್, it is also an important thing. So drafting committee was set up in August 29, 1947. Basic knowledge irli. But the drafting committee, we know Ambedkar ji had headed it. But who are the other members? Try to remember just one name. Krishna Swamy, Gopal Swamy, Munshi, K. Munshi, Sadullah, Mittar and Khaitan. These were the other members. Even this could become question in the subsequent years. That's why I wanted to talk. Same thing which I spoke, Constitution Day, National Law Day, celebrated on November 26th. I think this was it. I know 2023 paper was difficult compared to the subsequent years, but 2024 alli matte difficulty level dip aitu, easy level increase aitu. So this keeps on happening. ಈ ವರ್ಷ ಪಾಲಿಟಿ ಗಾದ್ರೆ ನೆಕ್ಸ್ಟ್ ಇಯರ್ ಮಾಡರ್ನ್ ಹಿಸ್ಟ್ರಿಗೆ ಆಗುತ್ತೆ, ನೆಕ್ಸ್ಟ್ ಇಯರ್ ಮಾಡರ್ನ್ ಹಿಸ್ಟ್ರಿಗೆ ಆದ್ರೆ or next year environment agate, or next year economic abut. So what is that we can do? The best thing that we can do is have a decent control over all of these subjects: polity, economy, environment, modern history, geography. Major core subjects alli we need to have control, and we need to balance it, or we need to give good amount of time for other upcoming areas such as mapping or IR or science and tech also. So in this way, ಪೇಪರ್ ಹೇಗಾದ್ರೂ ಇರಲಿ, ಟಫ್ ಇದ್ರೆ ಎಲ್ರಿಗೂ ಟಫ್ ಇರುತ್ತೆ, ಈಸಿ ಇದ್ರೆ ಎಲ್ರಿಗೂ ಈಸಿ ಇರುತ್ತೆ. ದ ಬೆಸ್ಟ್ ಥಿಂಗ್ ದಟ್ ವಿ ಕ್ಯಾನ್ ಡೂ ವೆನ್ ವಿ ಆರ್ ಇನ್ ದಿ ಎಕ್ಸಾಮ್ ಹಾಲ್ ಇಸ್ ವಿ ನೀಡ್ ಟು ಥಿಂಕ್ ಆಫ್ ಓನ್ಲಿ ಗಿವಿಂಗ್ ಅವರ್ ಬೆಸ್ಟ್. ವಿ ಶುಡ್ ನಾಟ್ ಥಿಂಕ್ ವೆದರ್ ಇಟ್ ಇಸ್ ಡಿಫಿಕಲ್ಟ್, ವಿ ಶುಡ್ ನಾಟ್ ಥಿಂಕ್ ವೆದರ್ ಇಟ್ ಇಸ್ ಈಸಿ. ದಿಸ್ ಇಸ್ ದ ಬೆಸ್ಟ್ ಥಿಂಗ್ ದಟ್ ವಿ ಕ್ಯಾನ್ ಡೂ ಟು ಕ್ಲಿಯರ್ UPSC Prelims exam, beat any year. So I hope you liked the video. Thank you for watching.